He is current in his childcare, but now he is $3,700 behind in child support.
She is literally spinning her wheels, trying to not support herself, but these grandkids as well. She's in dire financial straits.
Request to strike, set over, agreed continuances.
Your Honor, if Ms. Winkles is available, numbers 10 and 11, Overman and Webb, I believe we have basically a resolution for what reunification counseling would look like by agreement, given some of the issues between states, and are in agreement to get a GAL ordered today. And we have an outline for the reunification, with the only contingency being my client's meeting with the child's counselor tomorrow to confirm that it will all work out. Is that correct, Ms. Winkles?
Yeah, so our idea is to do, because reunification is state specific, is to do some video visits while the child's with their counselor, then to move to a daytime visit on a Friday for a few hours, have the child go to the counselor after that, assuming the counselor has time, and then have dad have some overnight visit on that same weekend in Utah with either his girlfriend or the sister present. So there's no questions, and then some video visits until our next review with the guardian ad litem.
And so do we need the next three GAL names, since that's sounds like an agreed request?
Yes.
Yes, Your Honor.
Okay, Heather Kale, Amy Turnbull, Ann Height.
Mr. Baldwin?
I'll strike the first.
All right, Ms. Kale, Ms. Winkles?
Yeah, I'll strike Ann Height.
All right, that leaves us with Amy Turnbull. So we'll appoint Amy Turnbull as the guardian ad litem in this case. And I'm assuming that is that going to be just presented ex parte?
Yes.
Sounds good.
All right, and no request for a future date at this point?
Actually, I believe November 28th is the 45 days for the review.
Perfect.
We can do
Thank you.
that.
And that's agreed.
Okay, November 28th, 2023, 1:00 p.m.
I think it's the only caveat. I have a flight. I'm coming back into town after being out of town that morning, but I should be in by 9. So 1:00 docket shouldn't be any issues unless there's any peculiarity at the airport outside my control. I'll be sure to let Ms. Winkles know, but that date should be fine.
Okay. All right, thank you very much.
Thank you, Your Honor.
Thank you, Judge.
All right. McCain and Abara, 13-3-00661-2.
Bear with us, Judge. We're playing musical cameras, but that matter is ready.
Okay. This I have is a show cause contempt, and there was some things filed, but nothing as of our last review on the 26th of September.
Is that right?
So where are we at?
So my understanding is we've been before the court. I think this is the third court hearing on my client's motion for contempt. Mr. Abara has appeared at every hearing. I don't know if he's here today, but every hearing he's appeared, he's indicated that he was seeking counsel. I think the last hearing he indicated that he was going to be making a payment to the babysitter in hopes to get current. I can report that has occurred. He has made some payments to the babysitter. The babysitter has been current. But to date, there's no filings, no attorney has appeared on his behalf. He's filed no formal response to my client's motion. Ultimately, my client was forced to bring this motion to get him to pay the, I think $1,400 that he was in outstanding childcare. We are asking still for a finding of contempt. Again, we had initially requested $750 in attorney's fees in our initial motion. Taking into consideration this is the third hearing on his request for setovers, I would ask that that be increased to $1,000 given the various hearings.
All right, thank you for that update. Does Shane Abara, are you present? *6 to unmute if you're on a telephone. Not hearing a response. I don't have anyone in my waiting room. In reviewing August 22nd and September 26th minutes, it appears that Ms. Bliss's rendition of events is accurate. We sent it over a couple times for an attorney. I know that that's been, I understand how difficult that is, but I also allowed him to serve upon the court and Ms. Bliss by email through today at essentially at noon. the information about being caught up. Is he ordered other payments besides the childcare, Miss Bliss, or is it just the childcare?
He currently has a child support obligation and childcare obligation. I think he was only behind in my motion, I believe he was only behind the childcare, and he had got current on his, he became current, excuse me, on his child support obligation. I know my client reported as of yesterday that he is current in his childcare, but now he is $3,700 behind in child support. So it seems that we're taking money from one obligation and putting it towards another and neglecting the other now.
Right, I do have a contempt order here. I will make a finding of contempt. He's not filed anything. What I'm doing is lining out the judgment for past due child support to 0 and indicating that that's been paid. Eliminating the civil penalty, and I'm keeping a lawyer fee. I am going to leave it at $750. And I will sign and file that order.
Very good. Thank you, Judge.
Thank you. Wrap 22-300400508. It's on for review. So thank you. So we have Mr. Rapp here. We have looks like a new MSC has been scheduled. Last time we were here, Ms. Bliss was covering for Mr. Zandy. Mr. Rapp was present, indicated he did jump through a whole bunch of hoops to try to log into the MSC, but wasn't able to. Said I would reserve on the judgment and told him to file proof that he attempted to attend the settlement conference. I haven't seen anything filed at this point. So Mr. Rapp, did you attempt to file anything in relation to that?
No, but I was out of town working.
Okay.
But I went in yesterday and made another $500 payment to Mr. Zandy.
All right. Mr. Zandy, any position? It looks like it was Judge Warning that imposed the $500 in attorney's fees for non-appearance at the mandatory settlement conference.
Yeah, this is a case that it had actually been reset for mandatory settlement conference. It was initially scheduled to proceed in late June. My client was ready. I was ready. We submitted our materials, and a day or two beforehand, there was a commissioner shortage, so that got postponed. We immediately reset that for early September. And again, same process, submitted our materials, logged on to the computer. Thankfully, my client didn't drive up from Southern Oregon, but nonetheless, she made herself available, and we waited approximately 15 or 20 minutes. It became clear that Mr. Rapp was not going to present himself, and Commissioner Warning did in fact strike that settlement conference, awarded the $500 in fees, and essentially gave us the marching orders to set it for trial. So I got to my office about 45 minutes later. We did receive contact from Mr. Rapp indicating that he had tried to log on but was unsuccessful. I did not speak with him directly about that, but here we are. I would remind the court that this is set for a review of the maintenance payments today. This is a case where the order has been in effect since about this time last year, and to date we have yet to receive a full payment under that temporary order. And my client continues to go backwards. Those efforts are frustrated then by the attempts to get this case resolved and settled. And we have various reasons why that hasn't happened. So that's first and foremost. I would simply ask, and I know it may be a little bit late in time to do this, and I appreciate Ms. Bliss appearing on my behalf last month. We need to get this done. My client needs some closure to this. If the parties can resolve the case informally, great. I would like to see this just be set for a half day or full day trial as opposed to going through the steps of a mediation, because that just for whatever reason doesn't seem like it's in the cards or meant to be, unfortunately. This leads me back to the, again, premise of the review today. Now we're again reviewing for I want to say 8th or 9th time the status of the support payments. Traditionally, Mr. Rapp will wait until the last possible minute and drop a partial payment off to my office. Now, yesterday, he's correct. I did have discussed with him briefly in between appointments the situation related to the mediation as well as the status of the support payments. He did drop off $500, but again, that's a drop in the bucket compared to what is owed. By my count, we're now over $16,000 between outstanding alimony payments coupled with the prior attorney's fees that have been awarded, and the fact that we just can't seem to get into a settlement conference for various reasons. We have suggested, and I think given the circumstances, it makes sense. My client is literally spinning her wheels financially, having these review hearings in which we show up and say, Mr. Rapp's made partial payment. Sounds like a broken record. My client's going backwards under that scenario. What we suggested initially, and this was not before Your Honor, I believe this was Judge Scudder who heard the initial temporary order hearing. We had requested that whatever maintenance was ordered, and we now know that's that $1,200 per month. We had simply asked that that be taken directly from either one of the retirement accounts, and there's a Social Security, there's also a pension that he has access to, or, which probably makes more sense, that Social Security, which is direct deposit. The Social Security is $1,443 per month. I think we can resolve a lot of these issues. I mean, again, the maintenance is $1,250. If we just set up an account in my client's name, Mr. Rapp contact Social Security Administration and say, this is the account that the award needs to go into every month. And we don't have to keep coming back every month on these reviews pending the time of trial or mediation or whatever way it is we go on that. That saves my client money. That saves both parties the need to keep coming back every month for these review hearings, and seems to make the most amount of sense. My initial request, the court had indicated last year, it was going to give Mr. Rapp the opportunity to make the payment and trust that he would do so. And here we are now 11 months later, and he hasn't made a single complete payment. I would suggest that the extra money, in addition to the $1,250 currently ordered, which again is going to be about $193, just be credited to the back amounts that are owed. And that gives my client at least somewhat of a basis, in addition to the $800 that she's getting per month in her own Social Security, to pay for her expenses. She has not been able to do that. She details for you in her declaration that she's relying off the gratuities of third parties down in Southern Oregon. She now has 2 grandkids, both teenagers, that are living with her, and she's not getting support for those kids. She is literally spinning her wheels, trying to not support herself, but these grandkids as well. She's in dire financial straits. I think the suggestion we have made makes sense and probably protects the interests. It also eliminates the need to keep coming back for these hearings as currently scheduled since last January.
All right. Thank you. Mr. Rapp, did you hear all that?
Yes, I did. I'm on a fixed income. It's kind of hard for me to make that big of a payment.
What's your income on a monthly basis?
3,600 some. She has, I know I make over $5,000 a month, and that's not right.
Well, I think Mr. Zandy's suggestion is not a bad one. You coming here every month is, well, or every few weeks, feels like it's monthly, is kind of a waste of everybody's time. And I don't, if you're making $3,600 a month and you're supposed to give her, I'm sorry, was it 12 or 14? 1,200?
$1,250 a month is what's owed.
Okay, $1,250. And you're in arrears now close to or over $16,000. We got to figure something out that's gonna fix this. Would you agree?
Well, I agree, but I'm trying to see if I can I want to find out what's going to happen so I can see if I can refinance and get a loan to get this taken care of.
All right. Well, at this point, I'm not gonna change the ruling from Judge Warning, so that'll remain in place. And here's what I'm gonna do. I don't know what your actions are or what you're trying to do to figure this out, Mr. Rapp. I'm going to set one final review, and if we don't have something sorted out, then I'm inclined to order what Mr. Zandy is suggesting to ensure that the payments that the court ordered a year ago are getting made moving forward until this case can be heard. And Mr. Zandy, if you are inclined to request the MSC be struck and get it set for a trial setting, I would be inclined to strongly consider that over waiting for this MSC, which it looks like it's not even scheduled until January now.
Correct.
Okay.
That was the earliest date I think we could get.
So I'm gonna, Mr. Rapp, here's what I've given you: a lot of leeway. I'm giving you a little bit more leeway, which I'm sure Mr. Zandy isn't very happy with. But we're gonna review this on November 7th. That's a month from now. You need to figure out how you're going to make the payments that you need to make on a monthly basis, which is $1,250. Or else, if Mr. Zandy proposes what he proposed today and we don't have another plan in place, then I'm likely to strongly consider that, if not grant that.
Well,
But-
my social out of my pension.
It needs to come from somewhere. Mr. Zandy's suggestion is, I think, a valid one. If you have a better suggestion, then I think you need to propose it. And you can't just show up here and talk to us about it. You have to actually file something. And if you need to reach out to Mr. Zandy between now and then to come up with a plan, I highly recommend you do that.
I do have an appointment with Mr. Zandy next Friday.
Perfect. So hopefully there's a plan. If not, then, you know, a thing that you're going to probably expect to start happening come November is Social Security going to Ms. Rapp.
So do you want me to present an order on the 7th as well, Judge, with today's ruling?
Sure, assuming that you don't have, assuming you don't come to another agreement, or Mr. Rapp doesn't have another alternative suggestion that would work for your client.
Okay, we'll keep that 7th date. I'll present an order at that time and we'll hopefully make some progress then.
Perfect. Maybe consulted with Mr. Anagnostou at the beginning of the dissolution process in this case. Okay, so that is a genuine conflict. However, on that date, while you were represented, it was relayed to the court and to opposing counsel that there was a plan that could be refinanced within the week, and that they would withdraw their motion for the sale of the property if it could be refinanced and taken out of foreclosure.
I got nothing in writing on that, Your Honor. That I was, as soon as that hearing started, then Ms. Ward indicated that we can't have this attorney. And then she said, well, we can have it. But then the judge said no, because if you don't allow Mr. Anagnostou to represent Mr. Couch the whole time, then he can't represent him here. But then they went on to start talking back and forth. There was no request for me to get proof of what you're saying now. Ms. Ward's saying, you know, now, oh, there, you know, like there's no proof of that. But I never got anything in writing that said anything to the fact that if I was able to get the money that they would drop this. It's kind of like the chicken or the egg. What's going to come first? I'm saying, please drop this, because, you know, deny this, the motion they have, because it makes no sense, because there's no time for them to take it back, put it on the market and sell it to meet the deadline, but it's holding me up because
But
I'm not
Mr. Couch,
able.
it's absolutely not holding you up. There's no way that this motion would bar you from refinancing and getting that property out of foreclosure. And anything in writing would be great, because you've never filed anything in writing as far as this is concerned. I understand you're in a position right now where you are entitled to an attorney. We are continually looking for that attorney. But what's going to happen now is your property is going to go into foreclosure, and then everybody's going to be lost on everything if you don't act. You're the only one that can do something here. And to be very frank, I don't know that if I granted this motion, that the people doing the foreclosure wouldn't wait and allow them to try to sell the property first. I don't know that. So we're kind of in a position where frankly, you need to be the first actor, and you say you don't have anything in writing. Well, it's part of the court record that Miss Ward indicated that they would dismiss the motion if you found a way to get the property out of foreclosure. So that's where we're at. We don't have an attorney for you yet. We're still looking. We're waiting for a callback from another attorney that popped up locally, but we're currently looking in Lewis County and Clark County to try to find an attorney for you. But there's nothing that says you cannot refinance and get this out of foreclosure because this motion is pending. And if you don't do that, then everybody's going to lose, because February 3rd or excuse me, November 3rd is quickly approaching.
Yes, Your Honor.
So
Yeah,
I don't, I wasn't here last week, but I spoke with Judge Scudder. I reviewed the minutes. So Miss Ward, if there's anything else.
I just like maybe there's some sort of fundamental misunderstanding with Mr. Couch. Just one thing to clarify is that his counsel did file pleadings in advance of the last hearing. And in those written pleadings, they stated that Mr. Couch was going to get the property out of foreclosure within the week. That is why we agreed to a set over, and the is the proof, right? Like when he makes the payment, we will know that he made the payment and got the property out of foreclosure. So we're not looking for any kind of like written proof. We just want him to make the payment and we will drop the motion. And I feel like Mr. Couch isn't understanding that the whole reason this motion is pending is because he hasn't gotten the property out of foreclosure. We want to make sure that if the property is going to be sold, it's not for a bargain basement price at a foreclosure auction. That is the whole reason this is pending. And it just feels like a broken record. Every single time we come here, there are more excuses and more delays. This has been pending for quite some time. My client is taking a hit by even agreeing to dismiss the motion because, quite frankly, she should be entitled to attorney fees given the ongoing delays. Mr. Couch should have been acting to get this property paid consistently before it even went into foreclosure. It has been months and months and months since he's been on notice that he's going to lose this property. And yet every time we come, he's asking for more time to accomplish something to get it out of foreclosure, though it's never been clear what that plan is. So at this point, we are asking, he had an attorney represent him, file pleadings on his behalf. In those pleadings, they state he will sell or he will get the property out of foreclosure within the week. He has not honored that. At this point in time, we are asking that the motion be granted, that any contracts he's entered into since this motion has been pending be set aside, but that be added to our proposed order, and that we be allowed to list it immediately to see if we can get it sold prior to the foreclosure. Because the reality is, if it goes to foreclosure on November 3rd, there's not going to be any equity in it whatsoever for anyone.
Ms. Ward, you indicated that your client, did she file a written waiver of conflict?
No, I emailed counsel after the fact. As soon as he emailed me a copy of his motion to be released from the case, I replied back and said that she'd be willing to waive the conflict if it meant that the case could continue to move forward so that there were no more delays. And I didn't receive anything back. I also don't know the status of the motions and orders that he filed. I didn't get a filed copy of anything. All I saw were his proposed drafts.
Would you be willing to send that to me as well? And the reason why is the judicial assistant that we have that works with the attorneys, if she reached out to Mr. Anagnostou saying, hey, they're waiving this, can you, I understand your position. I understand we're in a mess. Mr. Couch, do you understand that kind of the severity of the situation that we're in here now?
I absolutely do, Your Honor.
And do you understand that you're the only one that didn't do anything about it?
Yes, I'm trying my best, Your Honor.
So the last week, what have you done?
Last week, I've tried to coordinate getting this done, but I have no communications. Ms. Ward said that she sent that. I never got anything to state what you just were talking about. And
I replied all to the email from his attorney.
Your Honor, this is what I'm talking about. Ms. Ward just tries to walk over me and bully me, doesn't let me talk. And goes on, and I get to talk for like 20 seconds and I get cut off. And this is part of the whole problem. There's no negotiation. I'm trying to do the best thing for my family. The kids are involved in this as well as myself. It makes no sense to come back on this to try to take this property over when I'm the one in the best position to make it happen. They have no plan on their side. They say, oh, we want the property. How within that short amount of time then are they going to get the money? And possibly that the lender would give them time, but they're not communicating with me on that. We should be working together to prevent this, not holding me over a fire I have to do it with this looming over me. And then I finally get an attorney and then they smash him for nothing. That was not to do with this dissolution, Your Honor. That was in 2018 when the petitioner filed for a legal separation, and it had nothing to do with this case. And Mr. Agnostu doesn't remember it. There's no recording. There's no receipts. The petitioner said that she paid cash. I mean, it's at this point, why can't we just work it out? I don't understand it. It's just, I'm the bad guy here. And I've been trying my hardest. But now, right now, it's like, and each week, if you understand, we say, okay, now we got a week or 2 weeks. It's like having a weight on me. It's hard for me to even function, but I've been able to, coordinate it to where if this will go away, I can get the funds to get it out of foreclosure. But I know you're saying that it has nothing to do with it, but it has a lot, because you can't borrow that much money from friends and family and then have it taken away. Because this is like unclear. I can't equivocally say to them, yeah, okay, loan the money and your money's secure here, because the petitioner might get this motion to go through, and then I literally have to move out. I have no place to go. My children are out of a place of their income, and it makes no sense why they're doing this. It just seems more like retribution or something like that, because if they can answer how they plan on selling this place in less than a month, and I would like to know that. I would like to be involved in that. Do they have a buyer already? Because the company that
Mr. Couch, we're getting a little far afield at this point. If we're going to get down to like the brass tacks, you are so far in arrears on family support. This is the only asset that's left. That's why that's where the concern comes from. You're the one who has the keys to that building, so to speak, literally and figuratively. However, those keys are going to get snatched away from you and no one's going to have anything. So to me, this has been 3 months almost in the making that we're here. Now we're less than a month away from this foreclosure. There would be no grounds for me to order the sale of this property, if it wasn't in foreclosure. You're not going to get anything in writing from the court. You're probably not going to get anything in writing from Ms. Ward, but that's been stated on more than one occasion. I can understand them. They're not going to dismiss that until it's out of foreclosure. So that's where we're at. So you can either fix this problem by paying off the money, getting the property out of foreclosure, or we'll see if we can get Mr. Anagnostu back. And frankly, in his filings with the court, he told the court in the documents that you filed and signed with him that you were going to do this by today's date, and you haven't done it. So, but you're not represented, and you currently need to be represented. And it's a difficult situation to be in because we're now really under the wire. So I don't know how to stress that you're the only one that can control the outcome of this. Otherwise, everybody loses. And I know you've stated multiple times that this involves your entire family, and I don't doubt that. I don't disagree with that. And I don't, I'd love to think that you are considering the best interests of everyone. But you do have a mother of your children and another child that their payments have not been made to them. So they're trying to protect something that is potentially worth something. So I did reach out to my administrative deputy. She's going to reach out to Mr. Anagnostou to see if he can step back in on this case. And my hope is that he will with that waiver. So if you could just, Ms. Ward, I know you indicated you sent it to all the parties. If you could just send it to Superior Court Administration, so we have that. And if I'm going to set it over one more week to the 17th at 1. I know I closed that docket. If we could add this onto there. And the decision is going to be made by the 17th because we're in a position there. I can only guess. I don't know if the people that have it in foreclosure are willing to give additional time if the property is put up for sale. I don't know the answer to that. Mr. Couch, if you want to contact Miss Autumn Terry, I know you've gotten acquainted with her recently because she's been working on trying to get you counsel, but she's reaching out. She just sent me a email that she's reaching out to Mr. Anagnostou. So if you want to call her later today or first thing in the morning and see where we're at there. And there was one other attorney that was looking at their books to see if they could potentially step in. So reach out please to Miss Terry in the morning, and we'll review this on the 17th at 1. But we're getting down to, like, you know, everything's in the red now. So we are frankly nervous for the entire family here in this situation. So I hope, Mr. Couch, you figure out what you're going to do with this in the next week.
Yeah, thank you, Your Honor. It's difficult because I'm at a big disadvantage here. And so me trying to explain or articulate what's going on is very difficult for me. And
Your Honor,
Mr. Anagnostou was willing to take the case, and then, if I can understand, so Miss Ward has said that she sent something Mr. Anagnostou that said that he can represent me. Is that correct? Because she was saying just for this day, but there's a big difference. There's then one day he didn't even have time.
Mr. Couch,
No.
I can't keep going on this, but yes, she's said that there's been essentially a waiver by Miss Couch that she waives any conflict, and that Mr. Anagnostou could represent you in this matter.
Okay, that's great. Thank you, Your Honor. That I wish I would have known that.
Well,
Your Honor,
we didn't know that. I don't know if we knew that then, and I don't know if that's, yes, Miss Ward, go ahead.
I just want to point out, I hate to interrupt. Sometimes it's very hard for me to have an opportunity to respond. I did reply immediately when his attorney sent out his notice of intent to withdraw that my client would be willing to waive what is a valid conflict on her part, simply to move this forward and get this done. It looks like Kay Looney and Jay Wright with Cowlitz were both CC'd on that original email that I sent. I just forwarded it to the same individuals along with Superior Court as requested. And I just got a confirmation from Autumn Terry that was received. I just want to reiterate for Mr. Couch that the only reason this motion is pending is because we don't want it to go into foreclosure. If he pays the amount that is owed, we will voluntarily dismiss this motion. However, if we appear again in 1 week, and it has now been 2 weeks since he said he was going to take the property out of foreclosure, we will be asking that Your Honor grant our relief and set aside any contracts or other leases he's entered into while this motion has been pending, since it is only further encumbering the property without the authorization of the trustee. That's it.
All right. So Mr. Couch, reach out to Miss Terry in the morning, and the 17th at 1 p.m.
Thank you, Your Honor.
Thank you.